Joining us, guys. Really appreciate it.
Yeah. Welcome everybody to the first of what we hope will be a recurring event. We're going to have tenants' rights lawyers from San Francisco and across the state telling us, what are the things that we need to know to be able to enforce tenants' rights? What are the most important issues for people to be able to know, especially in this disastrous time of COVID, how to interact with your landlord in a way that will have better outcomes, and what are things that every tenant needs to know in order to be able to enforce their rights. I want to emphasize tonight that this is a San Francisco tenants' rights lawyer, and so we have a lot of overlapping tenants' rights, whether they're state, local, and not much federal, but that this advice is going to be general consumption for San Francisco tenants. It's not going to be any specific. I think actually, Michael, I'm going to hand it to you for the disclaimer and to tell you a little bit about your background and what you're going to focus on tonight.
Sure. So first, for the disclaimer.
Michael, you seem to have frozen. So Michael, I think you froze for a little bit. Can you start that all over again?
Am I back yet?
Yep, you're back.
Whew. Okay. Yes, I will do it again. Apologies if my internet gets weird. I pay for good internet, but goodness knows. Anyway, so first, for the disclaimer, as I alluded to earlier, I'm going to be providing general advice tonight. This is not in response to anyone's specific situation. I am not entering into an attorney-client relationship with anyone listening. This is general.
Crap.
Do you still hear me?
You said general information, and then we lost you for a bit.
Got it. All right. Let me try one thing. Okay.
Well, for those who are waiting, Michael's going to try something. He's going to call back in. So we're just going to hold for a second. Let's bring the pooch back. This is Frank. He's a dog. His name is Frank. He's great. We're just going to fill a little bit of time. Feel free to grab a drink. Okay, Michael, you're back, but you're muted.
I am back and I'm not muted. Again, keep forgetting that mute is default. Okay. So from the top, I'm providing general information and advice. It is not specific to anybody's situation. It is not an attorney-client relationship formed with any of the listeners or anyone who submitted the questions. General information, general legal advice. If you need information specific to your situation, you should consult a lawyer specifically about your situation. And that's not me, at least not tonight. Okay. In terms of intro, my name is Michael Zitani. I am a staff attorney with the Tenderloin Housing Clinic here in San Francisco. I handle no-fault evictions, which means I defend tenants in evictions for owner move-in or Ellis Act evictions, and occasionally temporary evictions for really big renovations. We also do some affirmative lawsuits on the side where we represent tenants suing landlords for really bad habitability issues. I went to Florida State for undergrad, went to University of California, Hastings here in San Francisco for law school. And I have been with THC since July of 2018. Yes, because I'm about to hit my 2-year mark.
Awesome. So you've been doing this for a little while, and I'm sure, how many tenants do you think you've helped over the
So I would say during normal times, obviously, non-COVID-19 pandemic, on average, I would usually have between 10 and 20 active cases, give or take. And each of those cases might have anywhere from 2 tenants to 5 to 6. So in terms of an actual number, there's a lot of math there, and I became a lawyer because I'm terrible at math. But yeah, hopefully that gives a rough estimate.
Okay. And what do you think, looking at sort of all of those cases, what do you think the most important things your average tenant needs to know going into, what might be a fraught situation with the landlord? What do you think every client needed to know? Sure.
So there's a few things that I think can kind of be helpful navigating any of the situations that can come up. The first one, and I think there's going to be some people that when they hear this first one, they think maybe I'm trying to pander to someone, but I think it's important just to say it and then we can move on. The landlord-tenant relationship in and of itself is not an inherently hostile one, but it can very quickly become so. Okay. I say this because in a vacuum, it seems like there shouldn't be that much to argue about or throw a fit over, right? You pay rent, you live in place, they get money, happy days. For those of us who are here and those of us who are dealing with these things not in a vacuum, we know frequently it is not that beautiful and not that sweet and simple. And so there are certain things we can try to do. First, be civil and professional when dealing with your landlord and expect the same back. That second piece is especially important. Expect the same back. Now, I have some clients that, they're friends with their landlord, even though they think they are, depending on the situation. And that's not necessarily a bad thing, but understand the landlord-tenant relationship is a legal relationship, and that legal relationship is where the rubber hits the road. Okay, in the unfortunate situation where maybe someone like me is representing a tenant and we're sitting in front of the judge in Department 501 of the San Francisco Superior Courthouse, the judge isn't going to be concerned about how good of friends the landlord and the tenant were, right? They're going to be concerned the landlord-tenant relationship. That's the meat of it. And so remember that civility and professionalism, and remember that if you're not getting it back, it's the first sign that there might be an issue. Now, moving on. Second point. When it comes to figuring out if you have an issue that's worth even talking about, right? Because I think that can be hard to sort of assess. Like, do I actually have a problem, or am I just being weird, or am I being overly dramatic? I think that's something tenants ask themselves a lot. Don't discount the power of the smell test. This applies to many things in life, but especially here. The smell test is incredibly powerful. I've had tenants that describe issues to me. They're like, yeah, it's kind of weird, but whatever. Or like, yeah, I know it's a little strange, but that's the cost of cheap housing. Or yeah, it feels a little rough, but I live in the city. What can you do? If it feels a little rough, it's because it's a little rough. It doesn't pass the smell test. There's an issue there. Trust your gut. It can get you farther than you would think. And the worst case scenario is you look into it and then it's like, all right, well, whatever, move on. But trust your gut. Does what's going on pass the smell test? And if not, maybe you need to move on and take some more substantive action. Third thing, and this is a biggie, and this is probably one of the moments where the folks listening are going to be like, oh, so here's that stereotypical lawyer moment. Writing. Do it in writing. I cannot stress this enough. I've screamed this to myself in my office sometimes because clients really struggle with it. Communicate in writing. Keep records in writing. And by the way, when I say writing, I mean letter and email. I don't mean text, okay? I say that because I have had some clients who, thankfully they're at least somewhat cognizant of this writing idea, and they're like, well, I get text messages. No bueno. Okay, we want to have things in email and letter because it's clear, it's easy to recover, and it can force people to frankly be a little bit more concise and professional. And last, but definitely not least, again, if you're in the unfortunate situation where someone like me is defending you, if we have to produce information to the other side as part of a lawsuit so that we can say, yes, as a matter of fact, this person did report that black mold on their bathroom ceiling. As a matter of fact, yes, this person did tell you that the front gate was broken. Being able to get that email out of a folder in your email or a letter out of a physical folder at home with letters in it is way easier than navigating 6 or 7 pages of text, taking 2 or 3 screenshots, sending them to me. Maybe they're right, maybe they don't attach. It's a pain in the butt. Pain in the keister, as one of my law professors used to say. So do it in writing. Do it in writing. I'm going to say it a million times. Okay.
Yeah. So interrupting you a little bit.
Yeah.
I have definitely had a landlord who refused to communicate in writing.
Mm-hmm.
My workaround was after a phone call where they said stuff and I didn't, was I would send an email reply saying, as you stated on this phone call, blah, 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 blah. And then they would call me to say, I didn't like it that you said that I said that. I'm figuring, that it was definitely an indicator for me. I'm wondering if you think those kinds of summary of what was said on a phone call, emails are helpful. Did they actually end up mattering?
Yes. So there's a few reasons why that's very important. And first and foremost, by the way, the experience of asking to do things in writing and having them refuse to do it is not unique. Unfortunately, that's one of the sort of side benefits of trying to do everything in writing is when they won't do it in writing, you're starting to get a feel for maybe this is going to become worse. But one of the reasons why that's really helpful is there's this idea in evidentiary law of past recollection recorded. And there's different evidentiary rules about it, but there's this idea that recollections that you write down at the time something happened or immediately thereafter are given greater credence because effectively it's you remembering it and writing it before you forget rather than, 6 months later being like, yeah, man, that's totally what we talked about. Yeah, great combo. So it's really huge. And the other thing is it makes it more stuck in your memory so that if bare minimum, the best we can do is have you talk about it later, you have something you can point to. You can be like, yes, he said A, B, C, and D, and I remember that because I wrote it down and sent it to him. And here's the email where I wrote it down and sent it to him right after hanging up. So that's very good. And that's a very good habit to get into if your landlord refuses to communicate in writing, because that way you're creating that record, you're helping your own memory stay solid, and you're making something that you can point to later. But yeah, good question. That's a really good question. I'm glad you asked that. Okay, number 4. This is another one that is very important. And if I'm being entirely honest, it's one that the first few times it came up, it always blew me away a little bit. If you have received a buyout offer, official legal correspondence, like a letter with a law firm name on the letterhead, or goodness forbid, an eviction notice, the time to resolve things amicably has passed, okay? The time to play nice has passed. I've had a number of clients who they've come through my door or, during COVID-19, they've given me a phone call on my cell phone, where they're telling me about an eviction notice they have. And I've reviewed the eviction notice. And I'm like, okay, here's what that notice means. And here's some things that you can start doing now, like keeping things in writing. And they say, well, isn't that going to make them a little mad? And isn't that going to rock the boat? And I cannot stress enough, the boat has been rocked. If we are there, we are rocking and we are rolling, and it is not fun. You know, I love the underlying desire there. The underlying desire of this is another human being. I'm a human being. Let's try and have a human interaction. But if that human being is telling you through some form of document, hey, I'd really like to see you out of this place, or hey, get the hell out, excuse the language, the time to play nice about it is past, and we need to act accordingly. No, it's negative news, but it's important because folks who try to keep playing nice can be taken advantage of. This is the last one I have. I have my notes here. You'll see me glancing from side to side. If you have an issue that when you look at it through any of these lenses that we just talked about, so it doesn't pass that smell test, they won't communicate with you in writing and you feel like it's a problem. They're sending you a buyout offer or you have an eviction notice. Talk to a lawyer who handles this type of law. That second part is especially important there, who handles this type of law. I've had some clients come in who they have friends that are lawyers, and those friends helped them. And thank goodness, you know, I mean, the more lawyers out there that actually use their legal license to help people, the better, right? Like, yes, yay. But unfortunately, they can sometimes do more harm than good. You know, occasionally it's whatever, and, you know, they help out a little bit or whatever they do, it's not a big deal. And at least in the situations I've had, me as the lawyer coming in afterwards can kind of pick up the pieces and go on. But sometimes the damage can be lasting that is done by someone who doesn't know what they're doing. I recently had a case that we just finally wrapped it up. The tenants, it was like a year-long legal battle. There was one letter that they had a friend of theirs who's a lawyer send, but not a lawyer for San Francisco rental law. And it's a letter that he sent before we were involved. And I kid you not, the contents of that letter were being fought about 8 months later. Multiple times a week. It was nuts. And that lawyer meant all the good in the world and was a friend of theirs, and I genuinely thank the man. But you as a tenant want to talk to somebody who can help you. And you are fortunate that here in San Francisco, there are folks who can guide you to those lawyers. You can go to the rent board and they can refer you. You can call the Eviction Defense Collaborative and they can refer you. You can even call the San Francisco Bar Association referral hotline and they can refer you. But talk to someone who actually does this, because the gulf in terms of results between what you'll get with someone who does do this and someone who doesn't can be very vast. It's very important to be mindful of that. Okay, that was a very long-winded answer to the main things for all tenants, but there you go.
Awesome. Well, so I'll pivot to our first question that got submitted, and I think it's top of mind for most people. What are the most important changes to tenants' rights since shelter in place went into effect? I think a lot of people are dealing with unique situations these days, and also the tenants' rights. So what do you think people need to know?
So the big three that I would say people should be aware of, and these are big three that I know they've affected at least the second and third have really affected my clients, but other nonprofits, the first one's really important. Payment of rent and what you can't, or what you can do if you can't pay it. Moratorium on most, but not all residential evictions, and issues and rules around construction. Okay. So let's start with the rent payment one. First and foremost, bad news bears. We all got to continue paying our rent. You know, sucks to keep shelling out all that cash in San Francisco, but it is what it is. But under the shelter in place rule, as I'm sure plenty of people have heard, if you can't pay due to COVID-19 related reasons, there's a certain amount of forgiveness there. You have up to 6 months after expiration of shelter in place to pay. But where the rub there is, and I think this is the part that's important for folks to understand here, how do you prove that? How do you actually show I can't pay my rent due to COVID-19? Now, the order, it talks about saying you can prove it. Let's see, I have the exact language in my notes. Where is it? Any form of objectively verifiable documentation that explains the financial impact the tenant has experienced. Now, that's some pretty vague legal language. Just going to come right out and say it. They do give some examples, but frankly, the examples are not that much better. They just say letters, emails, other communications, and then the two hypothetical examples they give are letter from an employer and unemployment insurance letters. But let's not kid ourselves. The real question there is, but what about privacy? If I'm trying to say I can't pay my rent due to COVID-19 related hardships, am I super thrilled by the idea of telling somebody else that either I'm affected by, or goodness forbid, maybe I have and or had the incredibly infectious virus that is an international pandemic scaring the living daylights out of all of us, right? That's not something someone necessarily wants to disclose to anybody.
Well, and
as much,
I mean, if you're not, if you're working under the table, how would you prove that? If you're undocumented, let's say, how would you prove that? If you're just getting fewer shifts, that seems to prove.
So that's why where I was going to go is this area of law, because frankly, the guidance in terms of what you have to provide is very vague. This is where it's especially important to talk to one of those attorneys I mentioned earlier. I don't handle non-payment of rent cases. That's not my purview. And so any claim of expertise there would be a false claim on my part. But there's intense privacy issues here that you have to be mindful of, just like what you're mentioning. Privacy issues around citizenship, privacy issues around your medical diagnosis or lack thereof. Maybe privacy issues, just like you said, maybe you work under the table. I mean, I have clients who, they don't have issues of citizenship, but their job is like being a weekend florist, which is a very beautiful thing, but admittedly, like you said, under the table concerns. So that's one of the big benefits of talking to somebody who can sort of help you navigate, for lack of a better term, disclosing just enough. Because here's the thing. If you don't disclose the right information, or that your landlord isn't convinced, and they try to file some sort of claim against you eventually, you can use the shelter in place as what's called an affirmative defense. You can say, look, man, I can't pay it, COVID-19, done deal. But we don't want to get there, right? We don't want to be stuck in a courtroom before you're explaining this and showing that, yes, I have this very real struggle. But you also want to do it in a way that doesn't violate your privacy, especially to somebody who, unfortunately, is probably a pretty hostile party. And the other thing is, and this is the other piece that is very important, and at least I personally haven't seen a huge discussion about it, is that, so the shelter in place, it encourages trying to come up with payment plans. This idea of call your landlord and you come up with a schedule, you come up with a plan. Now, this is beautiful in theory, but in practice, even as someone who doesn't handle non-payment of rent cases, but is attached to certain email chains, I've seen some pretty wild wiggity-whack in this area. Situations where a landlord tries to just make modifications to the entire lease, where they create this payment plan with incredibly unfair terms, incredibly prohibitive timelines on the tenants, with no downside to the landlord, and absolutely no recognition of the hardship that even necessitated the conversation in the first place. And so that part especially, this idea of coming up with a payment plan, there's such an inherent imbalance of power between landlords and tenants there, that you need someone on your side there, and you want to talk to a lawyer. And you want to use those resources, like I mentioned earlier, EDC, referral from the rent board, tenants union. There are a number of folks who can tell you where to go. But it's really important to do that because, I love the idea of being able to say, look, I'm being hit terribly by this virus. I can't pay rent, and getting some forgiveness and some flexibility there. But when it comes to stuff like that, it's just as much an opportunity for people to do good as it is for people to kind of abuse each other.
Is it more important for this to be more communicative with your landlord, that you're, at least saying out loud? One of the things that I've heard is you need to say out loud, I am unable to pay my rent due to COVID, and that magic term sets you down a better path than simply going silent.
I mean, so I have mixed feelings about that. On the one hand, I like the idea of being a little bit more open and communicative, because in theory, that promotes a more open and communicative relationship with the landlord, right? Be professional and civil, like I mentioned earlier. But on the other hand, and maybe this is just because I'm a little bit skeptical from, defending tenants so much and dealing, with landlord attorneys who are less than stellar. I can't help but think to myself, it's not gonna change too much. Because at the end of the day, if you've been saying it every day for the past 2 weeks and then you still can't pay rent, on the landlord side, if you haven't been saying anything for the past 2 weeks and you can't pay rent, it's sort of the same discussion. Regardless, they're not getting their money and they're upset about it. So I like the idea of being open. I'm concerned about the privacy, like I mentioned before. This idea of like, hey, just so you know, COVID's been getting pretty bad. My shifts have been going down. I don't know if I can pay my entire rent this month because COVID-19 has made it so I'm only getting 1 shift a week as opposed to my usual 6. My concern there is it's just that much of an earlier opportunity for the landlord to be like, oh, you claim COVID-19. Well, let's see some medical records. Oh, well, you know what? Just sign this real quick as long as we're at it and it's a modification to the lease. So I don't know. I like the idea in theory, but I'm concerned about the practical consequences. And, to some degree, it's also a matter of how foresighted can you be with it, right? I mean, we're sitting here talking about a situation where like 2-3 weeks out, you can't pay your rent due to COVID-19. But, there might be a situation where really it's that the week of your last paycheck, you get fired or laid off or furloughed. And suddenly it's a 3-day turnaround before you're having to explain that you can't pay rent. And so my thought is communication is possibly good, but as soon as you think you can't pay your rent due to COVID-19, talking to an attorney, a tenant attorney, about how to navigate that is definitely good. Does that make sense?
Yep. Great. So, and I think it's always good to consult an attorney specifically on these issues.
Yeah, and get ready to hear that a lot. I'm going to sound like a tape recorder. Apologies in advance. It's part of the gig. We got to tell you, talk to a lawyer, because talking to a lawyer is what gets you the results.
And we'll have those links at the end of this as well.
Yep.
So are there important protections or differences in renting a single family home or also a condo that if not an entire building's not being rented out, but just the condo, different types of housing really affecting what tenants' protections they should know about?
Yes. So general rule of thumb when dealing with condos and single family homes, and for the people in the chat who are listening, or for folks who submitted questions about these, part of the reason why these are actually together is because legally speaking, they are frequently treated similarly. Generally speaking, renting a condo or a single family home means you are not getting rent control, but you are getting just cause eviction protections. So what does that mean? It means that in theory, your rent hikes could still be somewhat vicious. They are not limited by either San Francisco law or actually state law in most situations, even under the most recent statewide rent control. But you still can't be booted out just because the landlord's feeling frisky or spicy. They still have to have one of the established just causes. However, because in law, we love to make things complicated, there are exceptions to that exception from rent control. I don't know all of these exceptions personally, but the main ones are going to be if you had a tenancy that started in, I think it's started prior to 1996 in the single family home or the condo. If the previous tenants in your single family home or condo were evicted under particular circumstances or change of terms, or if there was a certain type of health issue or health violation in the unit that caused people to leave. There are these very fact-specific exceptions to that exception to the rent control. And so if you rent a single family home or a condo, and truth be told, I haven't dealt with many folks who do. I think of all of the clients I've had since starting at THC, I have had 2 cases where there was a single family home rented. I don't think I've ever had a condo rental. But if you live and rent a single family home or a condo, and either A, your tenancy started before 1996, or B, you're aware that the prior tenants left under some sort of weirder circumstances, either eviction or health hazard or something along those lines, even if you're just a little suspicious, that'll be a good idea to talk to somebody about whether or not you fall in one of those very narrow exceptions, because there aren't many, but if you do fall in it, having rent control versus not rent control is a pretty huge deal. And so I would say that's really the main thing. I guess if I were in an elevator and someone's like, what's one thing people don't know about the rights they have in a single family home or a condo? It would be that generally speaking, you don't have rent control, but not all the time. And if you are suspicious, it could fall under one of those very weird, narrow exceptions. Talk to somebody. You might be able to push back.
And for people to understand just cause protections, what is the like sort of bullet point that they need to look for when they might be facing an eviction or starting to have I mean, I imagine I had a landlord who wanted to get me out and did not serve eviction papers or anything, but just wanted to have a conversation with me. What does just cause really mean for people?
So just cause, there's actually a very specific list in California state law for what constitutes just cause. And truth be told, I don't have it off the top of my head. But what I can tell you is big bullet points. Just cause is going to be things like you're somehow creating a nuisance, like you're damaging the unit, you're punching holes in the wall, or I don't know, something dramatic. Or you are a hazard you're creating some sort of physical violent hazard to those around you. Or, and this is the area of law that I handle, and hence why I'm a little bit more familiar with this piece, it's nothing to do with you. And it's a just cause in the sense that it's a decision by the landlord that results in eviction, not something you did wrong, like non-payment of rent, for example. That's the biggie, by the way. I should have started with that in terms of a just cause, non-payment of rent. That's kind of where you start. But yeah, so the last ones are ones where it's not as a result of any fault by the tenant, but rather it's supposedly a decision by the landlord to no longer be a landlord, and thus they evict you. But primarily when I say just cause, basically think non-payment of rent, trashing the place, not following your lease. That's an important one. That's actually going to come up later, coincidentally, breaching your lease, or one of those no fault issues I mentioned. Those are kind of the biggies. But again, there's actually a very specific list that you can look up online, and resources for that are going to be the kind of stuff you get from the tenants union or the rent board. Because if it's not one of those reasons, which by the way, situations like what you mentioned where they just want to talk, then that's a problem, because that can be illegal.
So one of these is a specific question somebody sent in. What tenants protections apply when a landlord is doing a mandatory soft story seismic retrofit? And especially if a building is non-compliant, and so they're having to do this mandatory soft story retrofit, what should the tenant be expecting? What resources the tenant might have?
Sure. So I want to start by saying I was really happy to see this question, by the way, because this is one that I've actually been seeing pop up a lot lately, and it's kind of weird waters. And so it's a really good thing to be cognizant of. In terms of, sorry, I heard someone weird yelling outside. Living in San Francisco. So in terms of protections while you're in a building that has seismic retrofit going on, there are city regulations, and the exact regulation, I think it's Administrative Code 62.5 big A, but I would need to double check. And it effectively says what I think is kind of the common sense expectation. During seismic retrofit, you will have housing services reduced. We got to start there. Okay. It's intense work. It's in-depth construction. It usually involves cutting off an entire garage. You will have some sort of services reduced. The landlord is obligated to pay you back for those services reduced, what are called severed housing services. Now, there are certain rules about how much they have to pay back in terms of like the value compared to your monthly rent, but by and large, whatever the value of that severed service is, they have to pay you back. Technically speaking, reading the administrative code, what they're required to do is pay half when they give you notice of this work. They have to give you notice in advance that they're going to be doing this retrofit. And then the other half when the work's actually going to start and you no longer have that service. So hypothetically speaking, you get a 30 or 60-day notice that says, hey, we're going to do the soft story seismic retrofit. Can't park here anymore. When you get the notice, you're supposed to get half of the value of the parking for the entire period of time the work's going to go on. And then when the work actually starts, you should get the other half. This is under the administrative code. However, practically speaking, what I think is more likely to happen and can still be a relatively fair result is you get that reduced, that service severed. You have this service reduced, and they just basically take it off your rent every month. So for example, I actually have a personal example where my building recently underwent seismic retrofit, and I couldn't park and I couldn't use laundry. The landlord just said, okay, basically take the value of what you paid for our parking every month plus an additional $25 a month for laundry, which frankly was a little low, but and just take that off the rent every month. That's how it should work, right? That's how it should go. And hypothetically speaking, there are situations where you might have to be relocated. Okay, there are tenant rights and actual specific rules about if you have to move during the seismic retrofit. If that happens, truth be told, the relevant administrative code is a little unclear because it talks about individual services being severed as opposed to necessarily the entirety of the housing services. But it also does specifically address that a landlord can just put you up in alternative housing that is close by. And it specifically says close by. So keep in mind, it's not like a landlord could say, hey, we got to do the seismic retrofit on this building in the Mission, but I got this real sweet studio out in Daly City. It needs to be close by. But more often than not, I think how that piece is going to work is you're going to fall into sort of the established rules for temporary displacement for capital improvements. And there are specific rules around that in terms of getting relocation payments, timelines for that, and sort of what the landlord has to do if they want to get that timeline extended. Now, the big money question that you asked, what if it's not compliant, right? This is all beautiful, but what if I'm dealing with a landlord who doesn't actually want to put in the work, doesn't want to actually fix the place? There's a number of things you can do. So let's say maybe the landlord's doing the work, but they're not giving you the proper rent reduction. Start by, again, that professional and civil I mentioned before. Tell them, hey man, I can't park. You have a giant pile of construction debris where my Prius used to go. I cannot park there. Now, truth be told, if you're having to do that, unfortunately, that probably means it's a situation where just sending that civil and professional letter isn't going to do it, but we start there. Then you can petition the rent board for a reduction in housing services, where you say, hey, I'm not getting this housing service. I shouldn't have to pay for it. And you can potentially get it reduced that way. If you feel that the construction is so bad that you just can't live there, I mean, maybe it's that you live on the floor right above that soft story, and literally every morning, 7 a.m., your floor vibrates so much you feel like you're riding a wooden roller coaster from the 60s. If it's something like that, maybe you give a call to the Department of Building Inspections here in San Francisco, and you say, please come out and inspect this. Please come out and see this. And if they or whatever other agency they may direct you to, because the beauty of DBI is frequently if they can't help you, they do know who can. I love those guys over there, by the way. Very biased. Just putting that out there now. But they can come out and they can say, that's not safe. You can't live here. And now you have a neutral third party to force your landlord to either relocate you into one of those comparable units I mentioned or go through the alternative means of temporary displacement.
And I think that all of this documenting is important.
Yes. Gosh, yes. It's another one of those situations, especially like what you mentioned with your landlord, right, about wanting to have the conversations on the phone all the time. This is one of those situations where it's especially important to be like, man, I need this in writing. This is very important. I need this for my records. So yeah, I would say those are the biggies during seismic retrofit, along with, the usual things of just because there's a seismic retrofit doesn't mean they can suddenly start wandering in and out of your apartment freely without notice, right? And other standard tenants' rights. But the ones I mentioned are sort of the biggies because I think those are the issues that tend to hit people hardest.
Okay. Let's try to get the next three pretty quick.
Got it. I enjoy the very polite way of saying, Michael, hurry the hell up.
Yeah,
good.
That's a little. What should people know about tenant buyouts during shelter in place? It's hard to move right now, and but people are getting offers for buyouts.
Yes. So first, start with the general disclaimer. My office does not do buyouts. We actually specifically discourage buyouts. We feel that they almost never give tenants a good result or as good of a result as they could get if they fight. So short and sweet version, I'm not the guy for buyouts. If you walked in my door and said, I want to buy out, I'd be like, cool, talk to somebody else. But moving on. Right now, the main concern, I think, is what you mentioned, moving. Okay. Otherwise, I don't think there's a whole huge amount of change in the calculus of like how buyouts are going to work. The law is still the same in terms of what papers you have to be served. The law is still the same in terms of moving or lack thereof. It's just now when you move, maybe you're putting yourself at risk health-wise because you're going outside. You're going where there are huge groups of people in the form of movers, contractors. You don't know if they're wearing masks or employing social distancing. So that's a big risk. The other point to be mindful of is that right now, and I don't know this personally, but I think it's a fair estimate, especially based on what you just mentioned, there is an uptick in buyouts, okay? Because there is that moratorium on almost all residential evictions that I hinted at earlier, but we kind of, we got things moving. Because the fact that it's pretty hard to evict somebody right now unless they're a threat to health and safety, there's a stronger incentive to pursue buyouts. However, doesn't mean the offers are going to be any better. There's not a whole hell of a lot of incentive to make good offers. So I would say understand that you'll probably see more buyouts, but understand that there is still a huge suite of rules that apply. And if you're getting a buyout offer, submitted lawfully or not, and unfortunately frequently they're submitted unlawfully, you need to talk to either a counselor at the rent board or an attorney about it. Because if they're sending you a buyout, that is them politely saying, we'd really love if you'd leave. And if you don't leave, we're probably going to escalate this to force you to leave and act accordingly.
Great. So this is important for me personally. Can you be evicted for having a pet when your lease says no pets? And I think this also applies. I have gotten written permission in the form of an email to have a pet, but it has not actually changed the lease.
So your explanation is the perfect intro for what my response is, which is the very time-honored legal response of it depends. So I remember I read this question in my very first class. I was like, I see you trying to get some free legal advice, whoever submitted this. And I feel you, but it's one of those scenes where it very much depends. Now, let's start with the question itself. Your lease specifically says no pets, but you have a pet and the landlord is upset about it. Technically speaking, in a vacuum, they could serve what's called a 3-day notice to cure or quit. Effectively says you are breaching actually the contract between us, i.e. the lease, cure that breach or get out. However, your statement about the email is the perfect illustration for why context matters here and why the response really is depends. Maybe your lease says no pets, but just like you said, you have this email where the landlord a while back was like, yeah, man, it's fine. Don't worry about it. Maybe your lease says no pets, but you've had a pet for 5 years, 10 years, and the landlord has known about that pet. The landlord has continued to accept your rent, and there's been no problem. Maybe your lease just doesn't say anything about pets. And suddenly your landlord is like, nah, man, no pets. That's how it's always been. The lease doesn't need to say it. Take all of that on top of the fact that your pet might be a service animal or an emotional support animal in San Francisco, and it really depends. So in a vacuum, technically speaking, can you be evicted for having a pet when your lease says no pets? Maybe. But I would say this is one of those situations, especially where context really matters. And little things like that one email, that one comment, that one lack of specific wording can make or break what happens over that very cute furry friend. Or lack thereof if you have a hairless cat. You know what I mean?
And in Corona times, I guess the 3 days to quit.
Yeah, and that's also an important thing to remember. I say 3-day notice to cure or quit, but during coronavirus, due to various restrictions and moratoriums on evictions and eviction notices, right now it's not going anywhere. There is a moratorium on all residential evictions except health and safety until 60 days after shelter in place expires. The Judicial Council is not issuing summonses for the lawsuits associated with this until 90 days after the state of emergency is declared closed. Not shelter in place, keep in mind, those are two separate things. But the state of emergency, it's only until 90 days after that summonses are even going to be issued. So the 3-day notice to cure or quit is the technical legal answer, but practically speaking, right now, not much is really happening there. Unless I guess they tried to say your pet is like trashing the place, but Frank there is pretty cute.
He would never.